To everybody on the webinar, it's Robert Bond with a cast of thousands here around the table who I'll introduce in a minute. It's our webinar, Legally Speaking, and we're going to be looking at the role of the Data Protection Officer. As usual, people are logging on at the last minute, so I'm going to put us all on mute for 2 minutes and then we'll start again. So we'll be with you shortly. Thanks. So once again, for all of you patiently logged on, welcome to our webinar today. The topic is the role of the Data Protection Officer, the DPO, as we will call that individual. We've got very few slides today because we are genuinely doing this as a roundtable discussion with some experts who I'll introduce in a minute. But in terms of me, I think most of you know me. I'm going to be moderating this session, and I'm a partner here at Bristows, and I've been doing data protection for a long time, and I was the data protection officer at my previous law firm. I'm currently not at Bristows at the moment, and I'm joined today by my colleague Hannah Crowther. Hannah is an associate in the data protection team here, and as you can see from the slide here, and Hannah's bio, has extensive experience in global data protection issues and has dealt with quite a number of leading or bleeding edge issues and binding corporate rules. And we've been asked by many clients in the last few months, do I need to have a data protection officer? What does a data protection officer look like? So I've asked Hannah to join our other experts to talk about the topic. And next we have Michael Bond, who is currently the data protection officer for GLH Hotels, Gloman Hotels, that own the Thistle Group and a number of others. And prior to that, Michael was in the team at News UK, part of the News Core Group, dealing with a range of issues around data protection. Michael sits on the governance board of the Data Protection Network and is an ambassador for Privacy by Design, appointed by Anne Cavoukian, the former Ontario Commissioner. And then we move from the leisure and hotel sector to Adam Green, who is with Equiniti Group. Adam is the Chief Risk Officer, but we'll find out what role Adam does or anticipates in performing on DPO stuff. And Adam has an interesting background from a number of sectors where he's firmly sat within the role of compliance overall. And I guess one of the topics we will talk about is, where does the DPO sit? Is it legal? Is it compliance? Is it ethics? What is it? And then finally we have Irwin Spilka, who is from the family office sector. And I'm going to get everybody to just introduce themselves in a minute and their roles. But Irwin is with the combination of Stonehage and the Fleming Group, and currently is the Data Protection Officer, but is performing a number of compliance roles and is a member of the editorial board of Compliance, which I'm intrigued to find out more about in a minute. So we've got a whole series of questions that we're going to go through, and it will be a miracle if we manage all of them. But before we get to the questions that are on this slide, and I'm not necessarily going to take them in the order that they are in, and thank you to everybody who has sent questions in, I'm going to start with Irwin and ask you just to say a little bit more about the current role that you have within Stonehage Fleming, and also perhaps explain a little bit more about what they do and what you think may be the change in your duties when we get to GDPR, the General Data Protection Regulation, and then we'll go round to Michael and we'll go to Adam and then we'll get into the questions. So Irwin, the floor is yours.
Oh, thank you. Let me start with Stonehage Fleming. We are what is referred to as an international family office, where we provide advisory and administration services to approximately 200 families, which are ultra-high net worth families, with regard to the long-term management of their wealth and often across generations. We operate from 11 offices in 7 different countries. My role in the group is that of Group Compliance Officer and Group Data Protection Officer, and I'm also the UK Data Protection Officer. I'm now finding that more and more of my time is being focused on the General Data Protection Regulation and data privacy, and we're looking at it as an area where we need to place focus. It's important.
Okay, and I was just one question. You're not what I would call the typical business to business or business to consumer, but do you see yourselves as B2B or B2C or something entirely different?
Well, if I'd have to classify it, it would be B2C, but the C's are rather special. The consumers are of a different type to normal consumers.
And of a type that would be more prone to be concerned about their privacy?
Would be extremely concerned about their privacy.
Okay, thank you. Okay, Michael.
I'm Michael Bond. I'm the Data Protection Officer for GLH Hotels, which is a UK-based hotelier, mainly with hotels in London, but serving a truly international clientele. We have guests from all over the world. My role is looking specifically at data protection and fostering a culture of privacy and trust within the organisation that our guests rightly expect from us. We deal with a lot of sensitive data relating to guest stays, and having the trust of our guests is hugely important to us. I'm fairly new in the role. I've been there for just under 2 months now, and so really it's a journey of discovery for me. What do we have in place already, what needs to be put in place, and also the added headache of, do we actually need a data protection officer? I was brought in on the understanding that I would report into our CEO. So you can see that the business is already thinking about how this role would sit within existing functions. I sit within audit and risk. The role previously sat within legal, but it's been shifted because the organisation is risk averse. We do think that this role is important from a risk perspective. So that's why I'm where I am.
So are you parallel to legal counsel or general counsel?
So I have 3 reporting lines. I report into the general counsel with a dotted line. I report into the CEO with a dotted line, and I report into the head of risk. So I have many masters.
Okay. And Adam?
So Adam Green, I'm Chief Risk Officer of the Equiniti Group and a member of the Group Executive. So Equiniti is a complex beast, but it performs a lot of trusted services for the UK financial services sector. So we provide share registration to some of the largest listed companies. We provide payment services to pensions and the life industry at scale. We provide direct-to-consumer business with a UK-leading proposition in retail stockbroking. And we also have a number of different technology businesses which all provide specialist, complex or regulated services in areas such as complaints management or know your customer, EPS and sanctions. and those sort of areas. So what we are overall, though, is a trusted provider of complex regulated services to mostly the UK financial services sector. And in my role, all of the risk and compliance aspects within the group ultimately feed up to the teams that I oversee, with the exception of the commercial legal, which sits on a different line, and we end up with the clear distinction between commercial legal, which is obviously managing issues and disputes, negotiating contracts, and then the compliance side, which is acting as advisory or to direct the compliance requirements.
Okay. And as we look at the questions that we've got up here, I know that a good number of people who are on the webinar today as attendees are experienced, but maybe I just need to remind everybody that we're in a current situation where under the current Data Protection Directive there isn't necessarily any mandatory requirement for a data protection officer. But there certainly will be under GDPR, and there may be very good reasons why some businesses that don't have a mandatory DPO may still feel we need to have somebody performing that function from a risk management, data management point of view. What is worrying for many businesses, and that's in part why we're doing the webinar today and why I'm grateful to having experts around the table, is that when we look at what GDPR says, and when we look at the recent Article 29 guide on the DPO, we've got an individual here who, if we look at the German model already, is quite a powerful individual with a protected position, who has to have appropriate technical and professional skills to fulfill the role, needs to be able to report to management, to not be conflicted, to be independent. What worries me is when you look in the mirror at yourselves, or indeed were you to be going out and hiring this character, what do you consider are the relevant qualifications, and what's the job spec for this beast, this DPO? And I don't mean that you're beasts around the table, but you know what I mean. Let's start with you, Irwin, because I know you've got a checklist as long as your arm there for the DPO. What do you think are the relevant qualifications? What makes this person?
Thank you, Robert. If you look at the requirements for appointment, I see there as being 8. The first is the ability to operate independently and without instructions and without conflict of interest. The second is to maintain expert data protection knowledge. The third is to be able to inform and advise the data controller or the data processor, depending which organization you're with regard to their obligations. The fourth is to discharge senior management level responsibilities with regard to staffing and management. The fifth is to have the responsibility for delivering timely guidance to the highest levels of the organization. Sixth is to understand what's involved in a data protection impact assessment, be able to carry them out within the organization. That would include privacy by design at the start of new projects and also with existing processes. Be able to manage a working relationship as the primary contact point with the supervisory authority, and to be able to recognize high-risk processing activities and take action where that's required, and mitigating steps that are necessary.
Okay. And Adam?
I think that's a fantastic list. It's starting to bring out some of the core qualities and relating those qualities back to the drivers of the regulation. I think, and just before the webinar, we were actually having a discussion here around the different qualities and the different things we look for in a DPO. And I think fundamentally, a DPO will tend to look like the company they're part of, because each organisation has a very different set of requirements and different set of skills and qualifications. So in the private client space, the level of integrity and the level of discipline required is very, very high. It's a very demanding client base. It's a very specialised set of skills. In some of the technology companies, you'll find quite possibly that the type of DPO you're looking for is somebody who's very technologically savvy, somebody with a much more corporate, much deeper corporate understanding of the mechanics of the company. Charities, for example, as we were talking earlier, Charities are a very special case because the DPO in charity has a very challenging job, particularly for those that deal with sensitive issues and sensitive personal data. So in terms of skills and qualities, looking at Equiniti, the type of qualities that the DPO would embody are, I suppose, in three areas. One is obviously the capability to understand the rules, but also the way that other rules that we are faced with interact. So data protection is one lens. It's an important lens, but it's one lens. So we have things like financial crime, we have things like the SCA regulations. All of those provide a different take on the same data. It's somebody who can communicate. They need to be able to take complex ideas, uncertain ideas, and then essentially win and sell over, sell and win over a broad variety of people, not least of all in the company, but actually particularly in the industry that we're in, which is processing, which is essentially to communicate with our clients and to work with them to understand their issues and drivers, and then also to make sure that as much as we understand them, they understand us. And the third piece, I think, given particularly I suppose some of the challenges that the data protection regulation poses, is somebody who's actually very resilient. It's a very strong force of mind, a very strong personality required to have to be able to work with some of the issues, particularly around sensitive data, if you have sensitive personal data. So again, hospitals or healthcare professionals, again, that's quite a challenging area. And so I think that's what I'd be looking for, which is a sort of series of attributes for that person.
And that is going to change sector to sector. And so I think it's going to be really interesting. You will find that there will be DPOs that will get deeply expert in a particular industry, whether it's medical, regulatory driven, or it's FCA type stuff, or legal. I mean, I don't know, what do you think, Hannah, is likely to be the attribute, and who would be the DPO in a law practice, if indeed you need one?
So I think I've been giving this some thought, and I think that in terms of the actual requirement, the obligation under the GDPR, certainly there are a number of law firms that handle a lot of criminal information, medical negligence experts, family lawyers, where we're talking about a firm here would be handling quite a lot of sensitive personal data, and I think they would certainly be caught by the GDPR obligation. I know that it's clear that individual practitioners don't have to appoint a DPO, but I don't think that applies when you're talking about a firm. And then talking about who it would be, if you are lucky enough to have a data protection team, then that would seem to be the obvious place since they have the knowledge. But otherwise, I think that law firms are very used to having a compliance officer, someone who looks after money laundering, and the SRA requirements, and that would seem to be a natural fit. I think that because law firms don't tend to do anything terribly new or exciting with the data, it's just day to day we do the same thing. I don't think it's going to be it's not a full-time role. There's not a huge amount to be said there. When you're appointing a new supplier, think about it, but most of the time I think it would be an easy role to fit in alongside your day job and another number of other compliance roles.
Though I wouldn't mind betting that there will be more, there'll be more panel due diligence done on certain firms where the client is going to say, we have to attain these standards. What have you got in place? And we're seeing that type of audit been going on for some years around what do you have in place around information security. Now, I do think we will find that law firms may have to be a little bit more realistic about the expertise that they're going to have for this, and that's going to be a challenge, particularly for the smaller firms that are doing family-related stuff or crime, etc. Again, where do you find this character, and how do you get them up to the standard that's needed? And again, what are your thoughts, Mike?
I think it's quite interesting saying that the DPO is going to become very specialised in a particular sector. I think you're probably right, but there are also going to be a number of skills that are completely transferable. I like to refer to myself as a bit of a privacy geek. So it's anybody that's going to have a deep knowledge of what the law says, a real sort of attention to detail, because that's where it matters sometimes. But actually, what the Article 29 Working Party is saying, and what I think you find very good data protection officers do, is they foster this culture of privacy. they start to break down the, oh, it's just the data protection officer telling me I can't do something attitude, and saying, this is how it actually relates to us, to you as individuals performing your functions. So if you can get around the, well, these are what the rules say and this is what you must do, a data protection officer is going to have that integrity, they are going to have a high level of training, but they're also going to be able to wear a number of different hats. Yes, the compliance hat, yes, the legal hat if they're a lawyer, but also the marketing hat, the HR hat, the technology hat. Not necessarily to be an expert in all of them, but to have enough knowledge and understanding of their business, whichever one that might be, to say, okay, this is how the rules should apply to us. So I think they're all valid points, really.
Picking up from Adam, you can also conceptualize this in a different way. I see one way of looking at it as the data protection officer performs a number of roles. The first role is the role of translation. Taking what the General Data Protection Regulation says and put it in a language that is understandable to people in the firm, be it policies, be it procedures, however that work of translation takes place. Second thing that the Data Protection Officer should do as a role is what I call broadcasting, putting the message out. It could be training, it could be briefing sessions, it could be newsletters, getting the message out. So you've translated and you've got the message out. The next role will be that of advice, because people will still need guidance. And the advice I see as breaking down into two different parts. The first is just advice for people who come and request it. But the second is working on projects where your expertise is needed. Now, if you've got the first three roles operating, the fourth role is to see, well, you've translated, you've broadcast, you've advised. Is it now happening? And that's monitoring, audit, and going out to see that what should be happening is happening. And if not, making recommendations and working with the business to get it right.
So that's really operating within a framework, a data protection framework, and you should always refer back to that, shouldn't you, I suppose?
Yeah. I've got a fifth role, and that's what I call change management. It's not all working.
No.
How do you now get in and manage change to get you where you should be?
Yeah, there's a question I'll come back to. Hannah, you just wanted to jump in as well?
I was going to say, it slightly moves on to some of our other topics, but I think that talking about translation and broadcasting is really interesting because I think they are very important. I think that is harder to do with an outsourced DPO, which is one of the things that we're going to come on to later. So by just much that, I think that is one of that sort of fostering a culture and breaking down the barriers is much easier to do when you are an in-house role.
Yeah, and well, let's come on to that one because it's sort of the first bullet point question we've got there. There's obviously, the ICO has said for some while, and there's pretty much an acceptance that you can have a consultant or somebody engaged on an external basis to do the job. But obviously it would worry me as to how you really can have your finger on the pulse when you are not inside the machine. And I think that's going to be really difficult. But the question we've got there is a sort of hybrid. So let's start with Michael. Do you think if you're sitting there as the DPO and you've got to master all these areas of expertise in your particular sector, do you think it's reasonable, safe, appropriate to do some of it but outsource some of it? And do you think that works from a compliance point of view?
I think that the premise that we've started off at is that the data protection officer is one person. And that's not necessarily the right premise to start from. The data protection officer can be a team of people. Often there will be individuals with more technical skills who can add strength to a group of people. And the Article 29 Working Party is very clear on this point. So if you are in a smaller organisation, unfortunately you're probably going to have to do most of this yourself. If you are in a position to have more people help you, or call on external advisors to help you, then where it is appropriate, then yes, I don't see why you can't outsource some of the functions. But you do need to be careful as to what those are. Because if you get it wrong, you could find that you are straddled with a data protection officer in an outsourced function who you can't get rid of, and you don't like what they're saying. But that's your problem because you've outsourced it. So you should think incredibly carefully before you do decide to do that.
Okay. And what about, we keep talking about the data protection officer. We haven't particularly differentiated at the moment between the DPO as mandated by GDPR that then has all the attributes and the duties and obligations, and a business that feels we would still like to have somebody performing the role of the DPO, albeit on a voluntary basis because it's good for risk management. Should you call them the DPO, or should they be given a different title, Ivan?
Well, I think this is it's a very interesting approach that has been taken, I think, in the Article 29 working paper, which is this idea that once you anoint somebody as a DPO, all of the rest flows from it. That seems to be what they're suggesting. And it is an interesting concept because the rights and obligations that come with it are quite extensive. But I think a lot of companies may find that having somebody termed potentially, and again it's a confusion of terms, but a privacy officer or a privacy advocate or something which is differentiated might be where they need to go. Somebody with that in-house sort of expertise to understand the company, but not necessarily to perform all the roles and duties that were set out as a DPO. I think also one of the signalling parts is once you go to the outside world, if you look at the way that GDPR is set out, it provides a lot of engagement points around the firm. So, for example, data subjects have rights of access, they have rights of request, they have rights around permissions, so forth for marketing. And the question is, if they see something with the title of DPO, they might readily accept that that individual is their advocate in the firm. And so I think part of it is to be as clear as possible with your customers and with the public about the way in which you're approaching this. So once you give somebody the role or title of DPO, once people were familiar with this regime, you'll set and train a whole chain of expectation with that, regardless of what you want to do internally. And I think you have to be quite careful you understand what you're doing.
And I'm going to ask Irwin just to comment on that, but also just as a sort of throwaway, as you were talking, Adam, it was just occurring to me that again, there's good guidance out there that suggests that the business should at least have some audit trail as to how it came to the decision that it didn't need a mandatory DPO. And if you did then find somebody that's going to perform this quasi role,
it does weaken that argument.
And at what point does the regulator say, we don't care what you call yourself, you're a data controller, like they said with data processors, actually what you're doing, I'm sorry, makes you the DPO. And then you have, well, how do you manage, Irwin, the situation where you're in X number of countries? Are you going to have a team of these people, or is there a risk that you may get someone that's rogue?
Well, we certainly are going to have a team, and we do have a team. And the roles differ depending on the countries. So, for example, in Jersey, we have a data protection officer. In Switzerland, we do not have a data protection officer because as soon as you have a data protection officer there, it's not obligatory. But as soon as you appoint one, you take on certain obligations with that role. So you want somebody who understands what needs to be done, but is not a data protection officer. I follow Adam's view is that where there are regulatory obligations imposed on you because of the appointment of a data protection officer, if you don't have to, then you shouldn't. Yes, you need someone for the role, but you don't need to give the title.
And while we've been talking, we've got a question come in which I'll throw out to Mike first. If the DPO role is carried out by an external provider, the role of the DPO could then be split. Is that possible if the role is entirely managed internally? Because I'm asking this because of the technical knowledge and the legal knowledge. Can you really expect, when you're doing all of these things, that you can possibly be the one provider as the internal?
Well,
is
yes.
the question.
Yes, because I do.
Okay.
At the moment, there is just me in our organisation that looks after data protection matters, and you have to turn your hand to pretty much everything. Now, I'm not suggesting for a second that I understand the technicalities of what encryption looks like, but I do know that there are technical experts within my other teams that do. So it's about drawing on those expertise and saying, okay, does this manage the risk from this particular perspective? Does it satisfy my comfort zone of data protection and privacy? So I think there's going to be a tendency of saying an external solution is fantastic because we can create lots of different roles externally with lots of different skills. And that's fine, and there will be lots of people that want to go down that route. But if you are internal, you've got two choices. You recruit more people with the specialist knowledge to act as a team of the DPO, or you have one person, and some organisations won't have a choice. They will have to do that.
But that one person's still got to have the other experts around him, like finance, like IT, like HR, and I would have thought that would make sense in any organisation, that you've got to involve the other stakeholders in the business. Adam?
No, I think it's an interesting concept, and going back to this concept of a person and what they are and what they represent. So, if you looked at other regulations and how they've panned out, so there are other regulations, and I appreciate not everyone on the call will be familiar with them, but one which is more familiar is money laundering reporting officers. So in the United Kingdom, we have this requirement, and they have to perform certain functions for firms much more widely than financial services. And the question becomes, how do you discharge that obligation? And it turns out that as a single individual, you can discharge the reporting part of it, but not necessarily all of the work that goes underneath you, particularly in large complex companies. So particularly in a bank, for example, you need to have tiers of engagement and tiers of trained individuals. But ultimately, you end up, and I think this is the point being made, is that there is always, and I think this is always the point, no matter what you do, there will always come up to a single decision maker. So if you were to go externally to a third-party firm, they will only ever be able to push the advice. The DPO is not obligated, they're not constricted, not constricted, they're not liable in the way that it's set out. They are they're there to drive that. But ultimately, you need one message. So I think the important point is, no matter how many different ways you find of putting it together, particularly for the big crunch questions, so there's some very big, complex things that pop up from time to time, you do want to decant it down to the decision makers, to the board, or in some cases to the shareholders, depending on how important these issues are, or to the media and the public, but to have one voice. But I think to come to it, you need a collection of individuals who are understanding of what that becomes.
Mm-hmm. It's also worth mentioning that the GDPR does anticipate where organisations try to frustrate the role of the DPO by saying it will provide adequate resource for them to do their job and also provide adequate training so they can stay up to speed. So, it has anticipated that there may be difficulties.
And one of the other questions that we've got up there a bit further down is could you opinion shop? In other words, the DPO says we are not going to implement this new technological solution because the PIA says there's too much of a privacy impact. Could legal override the DPO, or could external counsel override the DPO? What do you think, Adam?
Well, I think it's an interesting extension to some of the discussions that take place today. So very much in the same way that some of the international work and some of the more complicated cross-border work happens, firms form a view. So I'm very fortunate to have a number of very capable, very technically capable privacy professionals that work for me, and they have fantastic expert knowledge of our company and the rules. But every so often we run into a counterparty, and the counterparty has a very different view of the world, and we end up having to, in some cases, mediate our discussion through legal letters. So we end up with a lawyer on our side, they end up with a lawyer on their side, and effectively we're translating, in some cases, the discussion we really should have over a conference table into an exchange of letters. but the process is not altogether wasted because it does serve to really decant and clarify your view. So I think with the opinion shop, I think the essence will probably come down to, if you have the right DPO, you probably should never end up in a position where you end up fundamentally conflicted. And I think it comes down to this skills and qualities point, which is, and I've certainly had it, and it's I've bought Duff Legal Advice, and as a consultant, I used to give advice, and sometimes you go back and you think, was that all that I intended it to be? So I think there's an element of human fallibility in there as well.
Okay. I just want to come back to a previous point. The data controller has to document their decision as to whether they need a data protection officer or not. And there's got to be a cultural issue here, where if you've appointed a DPO because you think it's important and that you need one, why wouldn't you listen to them? I mean, compliance is ultimately the controller's responsibility, and the DPO is only there to advise, but why wouldn't you listen?
So I can see a situation where you would listen, but you still might, they're going to advise on the risk, and they're going to say, I think the risk falls on a no situation, and I think the business could still turn around and say, actually, thank you very much for your advice, but we think we're willing to take that risk. And I mean, a product launch is perhaps a more extreme example, but there are situations, things like prior consultation with the DPA, whether you think you need, with the Data Protection Authority, whether you think you need to report a breach, whether you think you need to do a communication to everybody who might have been affected. Then there's this obligation to, if you can't inform those people, whether you to put out a public statement. There's going to be things which have a huge impact on the business, where I think you can foresee a situation where they wouldn't have to be at loggerheads with their DPO to say, thank you, this is enormously helpful in terms of understanding our risk level, but actually we think we're not going to proceed, we're not going to essentially follow your advice. And then I'm sure that they would speak to their external lawyers as well, and they would listen to a variety of people. But and the same thing goes for when you have marketing saying one thing, saying this is just going to ruin our uptake on our marketing. This is going to have an impact on our revenues that you cannot imagine. They might just say, thank you, DPO, but we just can't take that hit. So.
And I think this is where the DPO needs to be commercially minded too. The advice is there to mitigate risk as much as it is to promote privacy. So you can't be the axe-wielding privacy maniac going, you can't do anything with this data because that would infringe the rights of individuals. There has to be a negotiation there with how do we reduce the risk of this activity to an acceptable level that still ultimately lets us get on with business, because that's what we're here to do.
I mean, I've found myself in situations where I say, this is my view. The business will say, we're not in agreement. So I'd say, fine, this is my view, and this is why it's my view, but if you wish to take an opposite view, these are the grounds that I think you should be basing it on. And I can help the business come to a view which may not be my view. That's the one scenario. The other scenario, of course, where you think they've crossed the line, then you say, I think this has crossed the line, but of course it's for you to decide. You should document your decisions. You should be satisfied with your decision. Normally, that's when you would consult with the law firm. If the law firm turns around and says no, it's fine. It's nothing that's personal. We're looking at a situation and trying to come up with an answer.
Okay. We've got another question come in which will take us in a slightly different tack. So we're sitting here anticipating GDPR. You are data protection officers in one form or another, and you're in international businesses. What do you anticipate is going to be the situation when we've Brexited and the UK is no longer in the EU, but you still have EU affiliates? You're going to end up with a DPO here and a DPO in the other lead part of your business, Irwin?
If you take the situation of Brexit, I formed a view, it's my view, may not necessarily be my firm's view, is that when we leave, we will not have equivalent status. So obtaining equivalent status is a technical exercise. It's difficult to imagine, it's possible that it might be solved as part of a political exercise. Then that's fine. But if it's the technical exercise that takes place, we will leave and we will not have equivalence. For us, the issue now becomes transfer of data. And we'll then need to address that across the group, and it will be an issue, and we'll need to use one of the mechanisms that then allow it to happen. Okay?
Sorry, I was just going to say, I think that this is an interesting one because I noticed the new guidelines are quite suggest that the DPO should generally be in Europe, which I think therefore might translate to the EU. But I think that there are a large number of organisations where the DPO could be so much more effective if they are where the decisions are made. And since there are so many companies which are headquartered in London, at least for now, it would still seem to me most logical to have a DPO where your decisions are made. And if that, whilst that remains your headquarters, I think maybe you have to have two, but it doesn't seem to me to be terribly logical to have to put a DPO in a subsidiary on the continent, which, if it doesn't play a large role, purely for the sake of having one in the EU. So to me, I think it remains to be seen, but I think they might have to accept that it actually makes more sense to give you more access to the board, more access to the marketing team, rather than necessarily access to the individual, since we're all on board at the same time zone.
Okay, so just expanding that one, because you and I will have had these questions a lot. You know, so many of our clients are US headquartered, and actually the decisions are made stateside. So we've got many pharmaceuticals, for example, who already have a chief privacy officer. They've lived with that because of US HIPAA laws, etc., much as the bank would have the same thing over there. And they're going, well, why can't I continue to do the role from here in Pennsylvania or in Arkansas or wherever? And you then say, but how you deal with language? I mean, it's all very well that you know the law, but how are you going to communicate the policy, the procedure in Slovenia, in Greece, in wherever you have it? I think you could say the same argument, actually, against what you were just saying, Anna, that I'm not sure that it just means where the decisions are made is where you have the DPO. You're going to have, I think, some local champions. Do you think, Anna?
Years ago, I used to work for PwC, and we had a lot of advisory around the relationship between America and Europe in terms of financial services. And one of the errors which kept cropping up, and you'd arrive after the fact, is that the American-based company, and it works the same way around, obviously, with European and American subsidiaries, we all do the same thing, but ultimately they will have filled a form out, or they will have sent a return in, or they've written a letter. It's landed on the European regulator's desk, or with the Bank of England, and it doesn't mean anything in that local jurisdiction. And suddenly you've got a regulatory investigation on your hands because the letter that was intended to provide the answer doesn't. And so then you get a big education exercise that happens very, very quickly to try and explain why the letter that was so carefully written didn't achieve what it was intended to do. And I think here the question will come there's a nuance in America, although the privacy is strict, there are, I detect, different mindsets and opinions, particularly from some of the Central European countries. There is definitely a different outlook to what these words mean and in whose interests you have to work. And also, going back to the level of commerciality, in the UK, the ICO has always been said to be a commercially minded regulator. But I notice, in common with a lot of other European regulations, the GDPR and the working group papers are very much looking for harmony, and they're looking for a consistent approach across all regulatory bodies. So to go back to the point about whether it will be technically possible or politically possible, I'm a bit of a political optimist, so I believe that on a technical basis, it's a nonsense to do it in that time. I mean, we wouldn't try and do that. But on a political basis, I think a political solution will be found, because as an economy, we're so interlinked with Europe. The timescales of Brexit are, they're too short. And I think some kind of either sort of temporary stay or some kind of political solution will be found to enable that transaction. I mean, on the simplest basis, airlines are going to have a terrible time of it. Holiday firms are going to have a terrible time of it. Booking a holiday in the Algarve is going to start becoming quite complicated, or for the travel companies. And so there's all these different elements which I think once people get to grips with them, somebody will try and resolve. But I think the local language, as it were, is important. You can never really, I mean, I would never even attempt to communicate with a German liberty officer because I know that we see things differently.
And just sort of extending that, do you think that we will still see nuances within the member states as to what the data protection officer is and what their power is? And do you think that we'll see Germany taking the very Germanic DPO approach, or do you think that we will have a level playing field? I don't know. Hannah, do you want to?
I think absolutely there will be huge nuances. Clearly, Germany, as the one where this is the most embedded as a concept, I imagine that they will continue to take a very similar approach to the one that they're doing now. And I think that I'm sure quite a few member states will look to that model, and so I would have thought that will have a huge influence across the EU, and so possibly to the extent there is harmonisation, people looking to that model. But I also know that anyone who has experienced it will know that there can be some problems with it. And I'm sure that you will see, just as you do now, I mean, I generally think that the level of harmonisation with the authorities is going to be quite different as well, and that will influence it. I think that we will see the, more pragmatic regulators taking a more pragmatic approach to the DPO role. The whole way that compliance is treated, I think, across the EU is quite different. I think, how important you see that role, what you feel about privacy, it varies so much. I think whether you believe in kind of black letter advice or taking a more sort of principles-based approach, I think that there will certainly be variation. And so I think, interestingly, if you're a group and you decide to appoint actually 2 different DPOs because you think we have several controllers, different business units, we want to look at different language capabilities, you could see some real differences between those two, the individuals, the roles that those individuals are playing.
So that's one perspective. I completely agree with it. Looking at what the Article 29 working parties say on this point, they very deliberately use the word accessibility. The DPO needs to be accessible. And to do that, they recommend that the DPO is within Europe. Now, if you go back to the concept of the DPO as a team of people, you can come back to Adam's point of saying, and Hannah's point of saying, the DPO sits with where the decision makers are, so the head of the data protection office sits there, and you appoint champions in each of your subsidiaries in Europe who speak the local language, that are available to the DPAs as required to communicate, and they can filter up those messages. So let's not necessarily think that it needs to be a DPO, but certainly part of your team could be there.
Okay. So I'm now going to go back to our 3 DPOs and say, as you look at what your responsibilities are under GDPR and the risks that attach to that, do you ask yourselves individually, and I guess I've got to say that your answers here will be those of your own and not necessarily those of your business, but what do you think individually you should be covered for in terms of your liability? Do you think that you should be covered by some sort of professional indemnity for the expert advice that you're giving? Should you be indemnified by the business for the consequences of you not being allowed to make a decision that then has an impact, and yet you're on record as the interface between the business and the DPA? Do you worry about personal liability as a DPO? Irwin?
As a compliance officer, I've always been, this is a compliance officer in a financial services regulated firm. I've been extremely concerned about personal liability. I'm the individual who's called for the PII policy, and I review it. I've requested changes to be made because I'm unhappy with the level of cover it provides for me. That's where I carry personal responsibility. I don't see myself having the same level of personal responsibility as a data protection officer. I see it in a different league. I'm not that concerned. I'm just happy with the standard PII policy. I wouldn't really go through it line by line as I have as a compliance officer.
Okay. And Adam?
Well, I guess going back to the point, I think depending on the role in the sector, you already have a lot of concurrent liabilities. So again, as a compliance officer, there are a number of interesting potential liabilities you face. I think recent FCA enforcement action has, in a number of cases, been against particularly egregious sort of derelictions of oversight, but they have fined individuals in their own right. They've come after them personally, particularly banks and insurers. This is now part of the mantra. But as looking at this regime and looking at the way it fits together, I would say two things. The role and the liability of the corporate and the directors and officers insurance, the D&O, I believe will definitely move in the market. So I have sort of interest in the same way you get very interested in insurance policies if you come into compliance. I've asked our brokers and the other brokers in the market what they're seeing, and underwriters are already starting to consider rate revisions. There's a bit of discussion around certain exclusions, certain policy endorsements required, and so on and so forth. No one's moved on it yet, but the general feeling is it's only going to go one way. But the area of focus has been predominantly on the boards and the directors and officers, insofar as they will have to make the decisions which ultimately will relate particularly to the fines, but actually I think more to the unintended consequences and costs. And to go, to go to the point around different levels of engagement, and that the individual versus the team, I think how you position yourself internally, particularly as regards the liability of the board and what they see as their remit, I think is very important. If you set yourself out as the authority in anything and your word is law, you have stepped over some line which takes you into personal accountability. And I think partly it's understanding the role for each company, banks, insurers, or pharmaceuticals, and understanding where that line is drawn. And I think, going back to the earlier statement, it is different for different companies.
Okay. One of the other questions we've got up there is that Article 38 of GDPR gives significant protections for the DPO. Do you think management are yet aware of the protections the DPO has, and where should the DPO be sitting? Is it legal? Is it compliance? Is it a bit of each of those? I mean, Mike, you've come in to a new job with a reporting role to the chief exec, admittedly to other lines. Has management got it? Do they understand what this new character is going to be under GDPR?
I think our organisation was aware of the importance of the role to start with, and where that sits in terms of departments, I think is going to become increasingly difficult. I've worked in businesses where the DPO has sat within compliance, which sits within legal, and I'm aware of it sitting in other functions too, like HR and technology. I don't know if any of those are right for this new role under GDPR. From what I can see, it's a floating position. It has to be able to sit at board meetings with senior execs. It has to be able to negotiate with middle management too. I've already said I have 3 reporting lines. The General Counsel is intensely interested in what I'm doing. The CEO is very aware, because we are a risk-averse business, of getting it right. And the head of risk is my boss, because I think that indicates just how seriously we are taking it. So different organisations will pigeonhole it in different places, but ultimately it's just a desk in an office, and the DPO will be out and about all over the place.
Okay. Adam?
I think, well, it goes back to this concept of what are they aware of. I think the one thing that all senior staff have cottoned on to about the GDPR is 2 and 4% of global turnover. That seems to have, people are aware of that one. I think I personally banished it from all slides. We've done that piece. The interesting, the role of the DPO is fascinating. I don't think people are generally aware of what this role entails and what it represents. And the concept of a rogue, when we're talking about this concept of a rogue DPO, and by that I mean my understanding of rogue DPO is somebody who becomes either misguided in their ambitions or overly officious in the way they approach their job, such that, going back to the point of commerciality, it's very difficult to get change and transformation to happen in the company. And so I think choosing a DPO is important. It's a huge amount of trust that you're placing in the individual. And in terms of interviewing and in terms of selection, I think it's a very high bar. And I don't think people are aware of that yet. They've had those conversations.
I agree with Adam. People don't seem to be aware of what rights attach to a DPO. How do you structure is an interesting question, and I think it is firm dependent. There are a couple of principles that apply. One, the role must report to a senior person in the organisation. But if you take a group, you're going to need to set up a governance structure. Let's say that you now have a group DPO and you have a local DPO. Local DPO needs to report to somebody senior in the local organisation. So you've now got a dual reporting line. The person who is probably more competent in providing guidance is going to be the group DPO, but he's not the person in charge of the relationship. So you now have to manage how that relationship works. And the two people who the DPO is reporting to now need to manage that relationship. And you'll get this played out in various ways across an organisation.
I mean, as you're speaking, and you're already as individuals and you're in organisations that are reasonably advanced in the thought process, if not in the actual implementation. But here we are with, just over a year to go, and clearly we know it with our own the inquiries we get with clients, and you've just said we're not sure that management's generally woken up. What do you think is what's the latest date by which somebody should have started thinking about the DPO role? And this isn't a trick question, but what do you think? Yesterday?
Well, I'll answer. I'll go.
Okay.
Go for sort of a broken answer. Again, it depends on how important it is to your business. If your business is really heavily invested in personal data or doing something which is interesting or complex with personal data, or you have a lot of it, so you're interested in vast amounts of personal data, and particularly if you're heavily, your core business is sensitive items, you should be thinking about it today.
Today, okay. Mike?
And they probably are. Those businesses that are data heavy will be intensely aware of these issues already. It's those that don't necessarily know whether they need one or not at the moment that may be sitting on their hands. As the data protection officer for my organisation, I've got a real difficulty because I'm going to write the assessment to say whether we need one or not. And internally, I'm conflicted as to whether I should be the data protection officer laid down in law, because is it career limiting? I can't be the chief privacy officer and the data protection officer. Mm-hmm. If we only need a voluntary DPO, we've been pretty much painted into a corner by the regulators anyway, because if you don't have one, and you could have appointed one, is it going to be an issue in an investigation? I'm sorry, you didn't have a data protection officer, you've assessed that you could have a voluntary one, that's going to be an issue for us now. You should have had one.
Okay. Owen?
Sorry, I've forgotten the question.
When should you be preparing for the DPO?
It's a question of how you put your project together. But if you put a project together on the basis of you need to structure what you're doing, you need to know where the people are, you then need to look at budget. That should have been happening last year.
Yeah, well, not everybody's that advanced. We're nearly up to the end of the time. There's one more question. I'm going to give it to Michael because it was you that said this. Someone mentioned that the DPO can be a team. How does this actually work in practice? Because surely one person has to be the DPO according to GDPR.
Okay, so what I would do is I'd have a head of data protection for your team. They are ultimately responsible for talking to the board and senior decision makers. You can then usefully go through the Article 29 Working Party opinion on data protection officers, pull out all of the tasks that they identify, and then put them into job descriptions as appropriate for each function. That's how I would practically look at it, and then decide, do I need more headcount? Can I do these roles myself? Where does the external person come in to assist me?
Okay, thank you. Well, we're up to 5:30, so I wanted, on behalf of everybody who has been on the webinar, to thank you for the questions that have come in, and B, on your behalf, to thank Adam, Michael, Hannah and Irwin for being so honest and informative with their own views about the role of the DPO. There were loads of questions that we didn't directly delve into, but I think we covered most of it, and I'm sure this won't be the last such discussion as we get nearer to May next year, but please don't sit on your hands, as somebody said. Do be planning for it. Our webinar is recorded, so as you know, it will be available from our website at Bristows in the next week or so for download, and as will the few slides that we got. On the 18th of May is our next Legally Speaking update, when we're going to be looking at a number of current topics, one of which is, does consent mean consent? We're looking at the end of the consultation from the ICO on the meaning of consent. We're going to also talk about legitimate interests and thoughts around how to legitimize legitimate interests. We'll look at the guidance that's come out on PIAs. We'll look at what the DCMS's view is on preparation for GDPR over here in the UK. So we've got a number of topics that the team here will be talking about. Again, on behalf of the presenters today and Jana, who's been helping me with the questions, thank you for being on the webinar. We look forward to being with you in just about a month's time. Thanks. Bye-bye.